Hey YouTube family and GN subs, how are you? Today I have a special update on a special immigrant juvenile visa. So those kids who came across the border, they were unaccompanied, they've been abused, they've been abandoned, they've been neglected, they get green cards. And also there's some new rules where they're able to basically get deferred action, which means they're going to be legal in the US. They cannot be deported, and also they get a work permit in the interim while they're waiting to adjust their status under this special immigrant juvenile visa. New rules, they take effect May of 2022. For those of you who are new to the channel, my name is Humberto Gray, attorney at law. I'm here on the west side, Los Angeles. And you know what I usually do? I'm known as the good news guy. I give good news. I also break down complicated subject matter, make it very simple to digest and understand. Today is one of those videos. Watch until the end. You know, basically I'm going to give you all the rules. You can look at them if you're interested, the new memorandum from immigration, etc. And then I give you real cases. That's the third thing I do, cases that I'm working on in my office. All right, but today all about SIJ visa. So let's get at it. A lot to unpack. All right, so a little background. So this SIJ visa came into existence under Act 90. It was a statute from 1990, and part of it was for special immigrant juveniles to protect them. Those, again, who were abused, abandoned, neglected, coming to the U.S., they don't have parents, can't go back home to their parents because of the abuse and neglect, etc. They are allowed to apply for a visa. It's through the I-360. We'll talk a little bit about that. That petition is approved, and basically then they can file the adjustment once it becomes current. So that was 1990. New final rule just promulgated by immigration. Well, the problem was with the visa, you need a court order, right? And in some states, if you're over 18, you can't get a court order that you've been neglected, abused, abandoned, etc. So particularly the Trump administration, they were denying petitions for those who were over 18 years old. Well, this rule makes clear if you make an application under 21, you qualify, which is fantastic, all right? And then also, as stated, a big problem with these applications was the priority date is under the EB4 category under special immigrants. They only allow 700 in per year from a particular country. So there is a substantial backlog. So what happens is an individual can get the I-360 approved, but couldn't file the adjustment until years later. So what do? They have an approved petition, but they can't get a work permit. So what the new rule does, it allows them to apply for deferred action and apply for a work permit through that deferred action. As we know from other videos, deferred action is you're legal in the U.S. They cannot remove you, can't deport you, and you're legal in the U.S. is fantastic for those who have an I-360 approved under this SIJ visa. This is great news. All right, let's talk about the legal requirements real quick, break it down. I put a link in the description box below that takes you to the USCIS website. It's actually pretty good. I'm surprised. It's already updated, and it's really good, right? So general requirements: under 21 years of age, currently living in the U.S., unmarried, a court order, and USCIS consent. Again, very detailed stuff, but if you go to the link description box below, it actually outlines exactly what that is. All right. What form is used to file the SIJ visa? It's the I-360. It's a special immigrant. It's the same petition that's used for like widowers, abused spouses, etc. I-360 is the form. You file it. They're supposed to adjudicate it within 6 months. They've been good at that. Once it's approved, then you have to wait for the priority date to become current. Again, we've had previous videos on the visa bulletin. Check those out. EB4 category, employment-based 4 category. You'll see backlogged, but once it's current, then you file the I-485, the adjustment of status, and you wait to get the green card at that point. In the meantime, you have that approved petition. Again, you can file for the deferred action as well as the work permit. Also note, we have previous videos, we talked about concurrent filing of petitions. If that priority date is current for your particular country, you can file the I-360 together with the I-485. That will ensure you that you'll get the work permit even prior to the approval of the I-360. So make note of the fact that you can concurrently file your I-360 with the I-485. In the description box below, I actually put the final rule. Those of you who love to dig in, go at it. It's 48 pages. There's a lot of good stuff in there. I've given you the thumbnail of what's really important in there, but those of you who like to dig in, there it is. Below also, I put the new memorandum, okay? The new policy of deferred action. Gives you the details, deferred action, work permits, and it's the authority, right? It's what immigration has to go by now. So if you're filing for the deferred action, put a copy of this memorandum in there so that immigration officers, they may not know. Now they know, issue the deferred action and the work permit in connection with your approved I-360. All right, YouTube family and GN subs, hey, thank all of you for the birthday wishes. Give me a thumbs up, like, and subscribe. I appreciate you. Thanks again, and we'll see you next time.